right, let's get started. Hi, everyone. Thank you so much for joining us this evening for our 2021 annual meeting. My name is Nicole Cordier, and I'm the fundraising and communications person at the ACLU of Rhode Island. I'm going to be facilitating tonight's hour-long event. Before we get started, I invite you to check out the event program that will be displayed momentarily on the screen. A couple housekeeping things I wanted to note before we really get into things is for security purposes, the chat has been disabled. But that said, we will have a Q&A session at the end, and you can submit a question at any time during the program. To ask a question, you mouse over the Zoom window and click on the icon marked Q&A. Then you type your question into the text box that pops up and press return. And all the submitted questions are going to queue up on our end, the panelists end here, and we'll address as many as possible before the close of the event. So without further ado, I'd like to welcome Heather Burbach, our board chair. Heather's going to give you a quick look at the past year's activities, and there's going to be a slideshow running simultaneously. Hi, Heather.
Hi, Nicole. Thanks so much. I'm going to go a little bit quickly because I want to leave as much time as possible for everybody, but there's a lot of things that have happened. I'm going to start on behalf of the board that we're pleased to welcome all of you this evening. We can't wait until we're all back gathering in person with you, but until then, we're glad that you're here at least with us tonight electronically. But despite the pandemic that's gone on and all the changes that it's brought, we've been able to do some really great work this year, and I have some successes that I want to highlight for you. First off, we were able at long last to get codified into Rhode Island law prohibitions on charging different insurance rates based on gender. This was a bill sponsored by Representative Kazarian and Senator Sosnowski and was signed into law in June by the governor. Also at the legislature, our lobbying was able to achieve a ban on people being denied professional licenses based on convictions for what they call a, quote, crime of moral turpitude, end quote, which is a hopelessly vague term that has created an enormous potential for discrimination for years. We're glad to have that gone. Sometimes once there's a victory in legislation, we have to follow up and ensure that it is interpreted in a fair way. And such was the case with the free tuition program at CCRI, intended to help students access an associate's degree. Students with disabilities sometimes require a little more time to complete the degree, and we were able to successfully advocate for students to be able to get that time and complete their degree when appropriate. While we try advocacy as often as we can, sometimes it's unsuccessful and we're forced to file suit. The next batch of victories comes from suits that we filed. First, after a long, hard-fought battle with the city of Cranston, a federal judge found unconstitutional the city's statute banning all panhandling, leafleting, and charitable solicitation. We also, as a result of a suit, were able to get the mayor of Woonsocket to agree to stop blocking people from her official Facebook page when they made critical comments about her. And you're going to be hearing more about this particular case tonight from attorney David Cass, who handled the matter for us. Voting rights issues have been the front and center this past year, and we filed a brief here in Rhode Island with the Bonnet Shores Fire District challenging their bylaws that limit voting only to those who own property. As we are all unfortunately well aware, there is a long and fraught history regarding tying voting rights to property ownership in this country. We also filed a petition with the State Board of Elections to make sure that clear, public, and non-discriminatory policies were followed before polling places are closed. This became an issue after last year's relocation and closing of polling places from low-income neighborhoods at the last minute without much notice. We're glad to be able to work on those issues as well. Frequently, we need to keep fighting to ensure that battles we've won stay won. Such is the case with the brief we filed with the Rhode Island Supreme Court. This friend of the court brief, also known as an amicus brief, urges the dismissal of a suit that is challenging the constitutionality of the Reproductive Privacy Act that we were able to get passed just a few years ago. Lynette Labinger will speak later tonight about this case and the stakes here in Rhode Island. One major victory came this year when the U.S. Supreme Court ruled that warrantless searches conducted by the Cranston police under the so-called community caretaking exception were determined to be invalid in the way that they were being done here in Cranston. Sometimes victories are big scale, like a Supreme Court case, and sometimes they're on a smaller scale and individual. In one particular case this year, the ACLU's legal action prevented an individual from being deported back to his home country, where there was evidence that returning him there would have led to his torture. Open government and access to government records is a constant battle that we fight, and the ACLU this year successfully represented a Roger Williams law student who, upon requesting a report that's required to be submitted to the General Assembly, was told that to give her access to that information would cost hundreds of dollars. Our advocacy successfully got them to back off of those charges for her. And you're going to hear more about this case later tonight from Lindsay Koso and Carolyn Medina, the attorney and law student that were involved in the case. The last legal victory that I'm going to highlight is one that was discussed at last year's meeting. Brown University sought to unlawfully cut some women's athletic teams. We sued just before last year's annual meeting and reached a successful settlement to reinstate the teams. Unfortunately, since then, that settlement has been challenged, but fortunately, recently the Federal Court of Appeals upheld that settlement and helped preserve the gender equality that we had fought for with that settlement. Unfortunately, while we celebrate our victories, this past year has brought us some unexpected sorrow. During the summer, Rhode Island ACLU lost 3 major champions of civil liberties in this state, and we're going to take a moment now to recognize these 3 community leaders.
Thank you so much, Heather. Yeah, as Heather mentioned, we've had some devastating losses this year in terms of the people who make this organization great. And with that, we have 3 people who have graciously joined us to honor these folks that have recently passed away. So without further ado, I want to welcome Carolyn Manis, who's going to share about the late Christopher Corbett.
Christopher P. Corbett, September 24th, 1963 to June 3rd, 2021. For those of you who don't know me, I'm Carolyn Manis, and I used to work at the Rhode Island affiliate in the mid to late 1990s. And I had the pleasure of working with Chris for a few years while he was Steve's assistant. What I remember most about that time is laughter. It was fun to work with Chris. We had a happy office. It was fun to go to work. Even though the office was involved in some very controversial cases at the time, including one against Barrington for plowing church parking lots, we always had fun. When I first started working with Chris at the ACLU, the office was located on Union Street. It was run down and the door to the restroom didn't close all the way and didn't lock. He would valiantly watch for me when I had to use the restroom. And at that time, I always had to use the restroom because I was pregnant. He always looked out for others. When we moved our office to Abbott Place, it felt like we were living the high life in those locations, in that location. And Fridays, he and I spent cleaning the office. And even cleaning was fun when you were with Chris. We used to pick up all the little pieces that Steve would pick off the edges of papers. We would laugh about it. The second thing I remember about our days working together with Steve was Chris's intellect. He was smart. He could cut to the heart of an issue. When Steve, Chris, and I would review cases going to legal committee, it was clear that Chris was going to be a brilliant attorney. He was in law school at the time, but his knowledge of civil liberties was well beyond his education. And he did become a brilliant attorney. I left employment at the ACLU and Chris graduated law school and became a practicing attorney. He served on the board of directors and handled a number of cases as cooperating attorney for the affiliate, and those will be highlighted in the program that we'll receive in a little while. He even served as plaintiff in a case against the city of Providence for its non-compliance with the Open Records Act. That case was favorably settled and the city had to change its ways. Steve and I lost touch with Chris for several years, but in 2019, out of the blue, I received a call from Steve saying that Chris was working in Providence and that he was going to arrange a reunion lunch for the 3 of us. It was a magical day, and it was as if we hadn't missed a beat. Chris was working at Bank of America in the trust department. He was a special fiduciary officer, assistant vice president. He joked that he was, quote, working for the man. Later that year at the annual meeting, Steve invited Chris and me to co-MC the affiliate's annual dinner celebrating its 60th year anniversary. It was fun, just like old times. The band was back together. This time we stayed in touch, and even during the pandemic, it was texts and phone calls. In June 2020, we celebrated when DACA was upheld. One night, we must have chatted on the phone for well over an hour. I am so incredibly sad to have lost Chris. It is especially sad to have lost him at 57 years old to COVID complications. I am told that Chris was scheduled to have his first vaccine shot when 3 days before he came down with COVID symptoms that proved fatal. Chris was a loving son, uncle, brother, and friend. Even in death, it was asked that in lieu of flowers at his funeral, quote, please consider sending good into the world. That's the kind of person Chris was. Losing him is a loss to all who knew him and a loss to the affiliate. Rest in peace, my friend. I hope you are in a better place. Thanks for the laughter and thanks for the memories.
Thank you so much, Carolyn. Barry Best has some remarks about the late, now Barry Best has some remarks about the late John Deneen.
Thank you. I'm Barry Best. I've been part of the Rhode Island affiliate for most of the last 50 years, and many of them on the board and the legal committee. John Deneen came to Rhode Island some 40 plus years ago from Pittsburgh, where he had been working as a legal services attorney. And it was Rhode Island Legal Services that brought him here. I worked there at the time. This was where I met John and first appreciated his finely honed sense of justice, his wry sense of humor, his work ethic, and his ability to play softball. He was well into his legal career by then. His first big case, having been even before law school, when having refused induction during Vietnam, he successfully defended his conscientious objector status. John was an iconoclast and a character, but his humor and unerring recognition of irony were only cover for a very sharp legal mind and an eagerness to take on big cases for people who would have been lost without him. John worked for Rhode Island Legal Services for many years, then transitioned to a private practice in which he was guided by the same internal compass to handle cases for what he might have called the little guy, or often in his ACLU cases for people whose causes would not be taken up by more mainstream lawyers. He handled more than 30 cases for our chapter. His interest in First Amendment free speech issues brought him a nightclub owner fighting a requirement for a special license to stage an all-male review, another club owner who faced a prohibitively large license fee to stage adult entertainment, an independent candidate for political office who had been excluded from participation in a TV station-sponsored debate, an IRS employee who was barred from publishing an article he'd written on pension reform, and in his last ACLU case, a police officer who had been disciplined for speaking out on police issues. In all of these cases, and in many more, he won outright victories or fully favorable settlements for his clients. A number of the court decisions were published and would be precedents for other advocates serving other clients. But John's dogged advocacy for his clients might be best illustrated by one particular case from early in his Rhode Island Legal Services days, when he specialized in housing issues and often represented tenants in eviction cases. In a landlord-oriented legal system, John sometimes needed to appeal an eviction order, but it was extremely difficult to do this because by statute, filing an appeal in an eviction case in Rhode Island required posting a bond that would fully protect the landlord for any expenses, including rent, that might accrue if the tenant lost the appeal. Since it couldn't usually be determined how long an appeal might take or how much rent would accrue, the required bond was often set at an amount that effectively prevented appeal. Can't meet the bond, can't appeal. John had a client who had received federal rent assistance under the terms of which the landlord had to agree that the tenant could be evicted only for good cause. When the landlord attempted to evict without good cause, John defended, of course. And when the Rhode Island District Court issued an eviction order and set a high bond for an appeal, John offered that his client would pay rent during the appeal, but could not meet the bond requirement. He formally objected to the lack of opportunity to appeal and challenged the bond requirement on due process grounds. When that argument failed in the state court, John filed a case in federal district court challenging the bond requirement and seeking a restraining order to allow his client's appeal to be heard. The federal district court denied that relief, so John filed an emergency appeal with the Federal Court of Appeals in Boston. He was unsuccessful there as well, but this is John Dineen we're talking about, so we're not done yet. He next sought help from a National Housing Law Support Center, which was impressed with his arguments and his tenacity, and assisted in filing a request for emergency intervention in the United States Supreme Court. In the end, he was unsuccessful there as well. But the reason I tell this story is for his postscript. When John called his client to tell him the sad news that after taking his eviction case all the way to the United States Supreme Court, the fight was lost, his client said, "Don't do any work on my case. I'm going to hire me a real lawyer." John laughed off the unintended irony and would retell this story not with frustration or annoyance, but with humor and pride in the hard work he had done for the right cause. And more to the point, undaunted, even energized by this setback, John shortly after began working with state legislator and our ACLU champion Liz Moranci to craft and pass a new Landlord-Tenant Act. Under the new law, a tenant must pay rent during an appeal, but the requirement of a bond to file an appeal no longer applies in any residential eviction case in Rhode Island. Of course, John was the best real lawyer his Supreme Court client or any of his clients could have had. He wasn't in it for the money or power or even thanks from his clients. He was in it to win the justice his clients deserved because it was the right thing to do. They and we remember and miss John. Thank you.
Thank you so much, Barry. Now I'm going to welcome Lisa Iwan to the screen with remarks about the late Jeff Melish. Hi, Lisa.
Tell me what's happening.
Hi, are you there?
Yeah, can you hear me?
Yep, we can hear you.
All right, I just have to say, following those two commentaries about two men that I loved quite deeply, it's very sad for me right now because I've been sitting here crying, and because I loved Chris Corbett and John Dineen so much, had so many good times with them, adored them so much, and just the work that they did was phenomenal. And now I have to talk about another phenomenal man, Jeff Melish. Jeff started practicing law in 1984, a year after I did, and his office was 2 doors down from mine. Jeff was an elementary school teacher before he became a lawyer. He was a very zealous advocate for his clients. He was such a zealous advocate for his clients that we lawyers in South County, when Jeff would enter on a case, we almost had to raise our retainer because it was like, oh my God, Jeff is in the case. He just would never, ever give up. He would never, ever give up. He was humble. He was hardworking. He was zealous. He was unflappable. And with the ACLU and also the entire community of the South County area, Jeff was consistently involved with uplifting the disenfranchised, the poor, and the homeless. He, at the time of his death on July 1st, he was on the board of directors of the ACLU and had been for many years, and he was on the board of the Johnny Cake Center. He constantly gave of himself, and he represented people that nobody else would represent. But for the ACLU, he took a wide variety of cases consistently over the 35 years that he practiced law. He took, well, that famous breastfeeding rights case. I mean, you know, women have the right to breastfeed their babies in public or anywhere. He took student rights cases. He took discrimination cases of every sort. He took federal cases. He took students' rights cases. He took cases in the family court involving civil rights and liberties. He was totally dedicated to helping the disenfranchised, the indigent, and the homeless. He took cases and never expected to get paid. I know this because I was appointed by the Supreme Court to close his law practice. And he has over $1.5 million in uncollectible funds. He's never going to be able to collect. These people have no money. They're never going to be able to pay him. But he was also dedicated to not just helping the person for that case. Because most people in family court, most people are homeless, who are indigent. They don't have one problem. They have 1 million problems. And Jeff helped the whole person. He knew all about public benefits programs. He knew all about helping people get housing, get a job, get training, get food, get shelter, even if it was night-to-night shelter. He helped the whole person. He was completely dedicated and committed to helping people. And his whole life was committed to that. And he was extremely humble and unflappable. And sometimes with his overzealous advocacy could be some kind of annoying, but you know, that's another thing. I mean, we all loved him too. I have to talk a little bit about Joanne because she was in the car crash too. And I want everybody to know that Joanne is doing very, very, very well. She doesn't remember the car crash. She suffered serious, serious injuries, but she's doing quite well. She, you know, had many, many broken bones and things, but she's doing very well. The first 4 months she wore Jeff, her left eye wasn't tracking and working, but it's healed itself. And she told me when I asked her today, what do you want me to say about Jeff? She said, tell everybody he was swell and I loved him. Jeff was a person that the whole community of Rhode Island is going to miss. And all of these 3 people who passed this year, I mean, I was sitting crying. I just missed them all. And thank you all very much.
Thank you so much, Lise. Before we wrap up this important part of our program, our executive director, Steve Brown, is going to say a few words. Steve?
Thank you, Nicole, and also thank you very much, Carolyn, Barry, and Lise. I really can't improve upon the sentiments you've expressed about how special these 3 people were. They all died before their time, and they left a huge hole, not only in the lives of their families and friends, but in the ACLU too. I knew and worked with all 3 of them for a few decades, and it's really impossible to quantify the scope and importance of their work for the affiliate. What you're seeing on the screen is a list of just some of the lawsuits they handled as ACLU cooperating attorneys. And their work in those cases, as Barry noted, they not only helped the individual plaintiffs they represented, but they established important precedents that will be protecting the rights of Rhode Islanders for decades to come. We all need to be grateful for that. We will continue to work for the justice that they strive for, but we will really miss them.
Thank you so much, Steve. That concludes this part of the program. Thank you, everyone, for joining us in honoring these folks. Next up, I want to welcome Carolyn Medina, one of our cooperating attorneys, who's going to talk about a recent successful open records case. Carolyn, welcome.
Thank you, Nicole. I'm a brand new cooperating attorney with the ACLU, and following that memoriam segment is truly humbling, and my heart goes out to everyone who's been volunteers with the ACLU for a long period of time. They sound like incredible contributors to preservation of individual liberties in Rhode Island. Our story is comparatively light in comparison to that. I would like to, I think the easiest way to tell our story is for me to introduce our plaintiff, Lindsay Koso, who is on the call, and let her tell a little bit about how she came to reach out to the ACLU for assistance. I believe probably most people in this meeting are aware of the Open Records Act, the Access to Public Records Act, and how it's supposed to work. And Lindsay, as a law student at Roger Williams University, had some help and yet ran into quite a bit of trouble. And so, Lindsay, would you like to just take it from here and tell your story of how you came to contact us?
Sure, thank you. My name is Lindsay Koso. Thank you so much for having me this evening. I just, like Carolyn said, I am a third-year law student at Roger Williams University School of Law. And last year I got into a spot of trouble while doing research for a law review article that I was writing. In my article, I was arguing that the landmark 2010 Supreme Court case Padilla versus Kentucky should be made retroactive in Rhode Island. This is a case that would mean that non-citizens in Rhode Island would have incorporated into their Sixth Amendment right to competent counsel. They would have the right to be informed of the possible impact of pleading guilty or no contest to a crime on their immigration status. Now, I don't want to get too much into the weeds, although I could talk about Padilla versus Kentucky all day. The trouble sort of came when I wanted to make this piece of legislation retroactive in Rhode Island because I saw it as having a really, really beneficial impact on a particularly vulnerable part of our state's population communities. So to support my argument, I went looking for statistics because who doesn't love statistics? And I found a law, the Rhode Island General Law 12-12-22, which directly supported my argument and would give me about 20 years worth of statistics to support my argument for the non-citizen population of Rhode Island. Essentially, there was a clause in this piece of legislation that said, in the first week of January 2001 and each year thereafter, the Attorney General shall submit to the General Assembly a list of cases in which a disposition was vacated pursuant to this section. So somewhere there was 20 years worth of records that were going to help my paper. I went to the legislative library. They had never heard of this filing. I called the Attorney General's office. They told me to talk to the legislative library. I was ping-ponged back and forth between government officials and offices for weeks. And I finally nailed down a contact in the Attorney General's office who said he would get his people on it and get back to me. And it got pushed back and pushed back and pushed back. And I was sitting there thinking, these are public records required to be filed by the law. And I'm a law student and I have access to so many people to help me and so many resources to find these records. And yet here I am months into trying to start writing this paper with no luck. Finally, I filed an APRA request and the Attorney General's office came back with no results, demanding that I pay $225 upfront for them to start looking for, or to continue looking, sorry, not start, for the records that I had requested. And if I didn't pay them promptly, I would lose this APRA. So that's when I asked a professor who talked to a colleague, who talked to a colleague, and I ended up in a meeting with the executive director of the Rhode Island ACLU the day before Thanksgiving, and met Carolyn. So go ahead.
So, thank you, Lindsay. And then, you know, we tried to move quickly because, as anyone that's involved in attending law school knows, when you're writing a note, you have certain deadlines. And the recalcitrance of the Attorney General really was making it difficult for Lindsay to complete her note for school. And so there were Lindsay received a letter from the Attorney General's office, and there were two primary civil liberties concerns raised by the letter that she received. And the first was the fee. She was being charged upfront. She was being told that the search for the 20 years of annual reports regarding dismissals of criminal cases under the statute she cited was going to take 15 hours of searching at $15 an hour, and she needed to prepay $225. For a law student, that is prohibitively high. Additionally, if she did not pay that fee within 30 days, they were going to close her request and consider the matter done. So they had taken well more than 30 days in running her around prior to sending her that written response. And yet she had to come up with the money pretty fast, or else she was not going to have access to these records. Just by way of background, I'm a housing lawyer. I haven't been to court in 17 years. And I did not at the time have an account to file any complaints in a court in Rhode Island. I must thank Lynette Labinger extensively for her handholding and help and just critical assistance in getting anything done at all. But I did draft a complaint, and we noted several concerns with the handling of this matter by the Attorney General. That complaint, we sent that complaint over. Even prior to it being served, we did get a response from the Attorney General expressing their sheer shock and surprise that why on earth would we ever have needed to file a complaint in order to get these records, because they so reasonably produced them to the Boston Globe when news of our complaint made the press. We found that ironic, among other things. Also non-responsive. And so we did respond to the Attorney General, reiterating the need for the production of the documents. They finally admitted that the Attorney General did not produce these reports. It had not produced the reports in compliance with the statute from about 2002 through through the present time, but they were willing to recreate several years of the reports, which they did do. They produced those. And so that was a win for Lindsay, but it didn't solve the immediate problem, number one, of the fee they were attempting to charge, or the timing constraints that they were attempting to impose. Given, however, that they had produced the documents that existed and recreated what they could from the records that they had access to, we really were in a position of not being able to push them too hard. However, we produced language to the Attorney General that we strongly recommended they consider adding to their APRA request form, which is presently produced to the public online, that would have notified the public about the availability of statutory access to waivers of these search fees. The AG's office declined our request, although they noted that they took our recommendations seriously. But we do, I personally think we should continue to pursue better publicizing of the access to fee waivers, because that continues to be a prohibitive influence on APRA requests. The other aspect of our lawsuit involved the closing of matters after 30 days if the fees weren't paid. And on that, the AG actually conceded that they would no longer continue that practice. They would inform applicants seeking records under APRA that their matter they had the option to request that their matter be held open longer than 30 days, or that they be allowed to resubmit their request. And so that gives the public a better ability to continue an APRA request while they attempt to comply with these really at times very onerous search fees, which I hope we continue to challenge as we can.
Thanks so much, Carolyn. And Lindsay, thank you so much. Now I want to welcome Paige Clausius Parks from Rhode Island Kids Count. She's going to talk a little bit about our organization's joint work on policing in schools. Hi, Paige.
Hi, good evening. Thank you everyone for, and thank you Steve and ACLU for inviting me to speak this evening. As you heard, I'm Paige Clausius Parks. I'm a senior policy analyst at Rhode Island Kids Count. And my work focuses on economic well-being policy as well as education policy. And it's been a pleasure to work with the ACLU this past legislative session on many bills that involve school climate, especially the school policing work. So I'll start off just by describing what school climate means, as this is a really critical part of the policy work that Rhode Island Kids Count is working on. So school policy is described, school climate is described as a character, as the quality of life that happens inside of a school building is defined by many indicators and includes relationships, so teachers' relationships with students and families and the broader community. It includes the facilities, the safety, availability of school-based health supports, and includes the discipline policies, as well as the academic outcomes. And so a positive school climate, as you can guess, it promotes social, mental, emotional, behavioral, and learning success. And it also includes physical and social safety. Now, school resource officers, also known as SROs, are police in schools. They serve many functions in a school building, and those functions also include enforcement of student discipline. Now, national research suggests that the presence of law enforcement actually worsens school climate and increases disciplinary actions and disproportionately impacts the academic outcomes for students of color. So it's no surprise that Rhode Island Kids Count and the ACLU be really, really interested in trying to work on this piece in schools. So for the data connected to this, so the most recent data that we have in Rhode Island during the school year of 2015 and 2016, Black students that school year represented 8% of the student population, but were 23% of students referred to law enforcement and 23% of students with school-related arrests. I mean, they were arrested there at school. Hispanic students were 24% of the population, but they were 47% of the students referred to law enforcement and 36% of students with school-related arrests. White students, however, were 60% of student enrollment that year, but they were only 18% of the students that were referred to law enforcement and 25% of the students with school-related arrest. We can also see similar disparities if we're looking at students with special needs. So students that had individual education plans, they were 15% of the student population that year, but they were 22% of the students referred to law enforcement and 29% of students that had a school-related arrest. So as I'm sure many of you know, student arrests in juvenile detention increases the student's likelihood of future arrest. It decreases the likelihood of completing high school and may result in long-lasting consequences that include restricted eligibility for federal grants and for student loans, and barriers to college enrollment, and ultimately employment as well. So we partnered with the ACLU this last legislative session to support and introduce legislation that would require the Rhode Island Department of Education and the Attorney General's office to collect and publicly report data around school resource officers. You may be surprised to know we have police in our schools, but we actually don't have a lot of information about how many they are or what are they doing in our schools. So the bill that we supported would require RIDE and the Attorney General to report the number of SROs. We don't even have that data yet. How many SROs are in schools, the use of force against students, the student arrests, the referrals to law enforcement or to courts, and to disaggregate this data by age, by grade, race, ethnicity, gender, disability, and language status. So we know this legislation is extremely important because police in schools is problematic and it could contribute to the school to prison pipeline. And without this really important data, all we have to rely on is just anecdotal experiences. And we need the data. We need to know what the police are doing in schools and to ultimately have them removed. They do not improve school climate. So we just are really happy to have this partnership with the ACLU. We will continue to work on this bill and hope to eventually get it passed. And that's all. Happy to answer questions if there are any, and looking forward to the work ahead. Thanks.
Thank you so much, Paige. Thanks for joining us again. Welcome back. Let's see. Now I want to welcome Attorney David Cass, who is joining us to talk about our recent successful First Amendment case involving social media censorship. Welcome, David.
Thank you, Nicole. The case that I was fortunate enough to handle, I was brought in by Lynette Labinger to assist in this. And I want to thank you, Lynette, for thinking of me and allowing me to be a part of this case, because it's meant a lot to me, but also to my family who were able to help me out a little bit here and there. But on this case followed kind of along the path of the prior cases, one being the Trump Twitter case, and the second one being the Attorney General Ken Paxton case in Texas, which was handled by the Texas ACLU. And I was fortunate enough to have that kind of blueprint to follow in order to reach a positive result in a shorter period of time. The issue that arose was that the mayor of Woonsocket, once becoming the mayor, had used her Facebook page as a governmental instrument. She had labeled herself the mayor of Woonsocket on her page and used that Facebook page to post governmental information as to voting, as to issues, as to actions that she took and that she supported and that she was accomplishing in her position as mayor. The two plaintiffs in the case took some issue with some of the matters she raised on her Facebook page and some of the credit she took. And in the scheme of things as they develop in politics, the issues that arose on this Facebook page seem fairly innocuous. The initial plaintiff that we started assisting, Gregory Duhamel, was challenging the mayor's taking credit for building a skate park. And the second plaintiff had simply asked questions about the status of the budget for the public library. And for their inquiries on her Facebook page, the mayor found it necessary to ban them from access and ban their comments. They then sought the assistance of the ACLU, and again, through Lynette Labinger, that came to me. And with that, we were able to research the Facebook page, pull out the posts, and put together a complaint, again, similar to the Ken Paxton case in Texas. We were able to put into the complaint a lot of the posts for proof purposes as to the nature of the Facebook page and how it had turned into and was used as a public forum, a governmental public forum. Prior to filing the complaint, we did reach out to the city solicitor for Woonsocket to try and see if we could get just a voluntary compliance and effectuate an elimination of the bans. The solicitor's office, in essence, failed to respond, and just our requests fell on deaf ears. And so from there, we initiated the complaint with a motion for a restraining order. And luckily enough, the assigned attorney realized the proper nature of our complaint. And it was Mark DeSisto, who was usually not the attorney I would say would be the first to come to the table in these instances, but based on the nature of the actions of the mayor, as well as I think what was a clear case on behalf of the ACLU, upon some negotiation, they agreed to everything we asked for. The mayor, in essence, removed her bans not only on the 2 individuals that were plaintiffs, but also agreed to remove any bans on any individual she had banned on her Facebook page. We were also, and so from that, we were able to achieve I think a very positive result with a minimal of an argument and fight. And I think it's going to turn itself into kind of a cottage industry with the fact that social media has become so omnipresent, and the thin skin of politicians seems to be never ending. So those two are going to run headlong into each other and provide the ACLU, I think, with a lot of options, a lot of opportunities to continue to fight this battle as it moves forward into the future.
Thank you so much, David. We're running a little short on time, but we had something planned to break up the program a little bit. So I'm just gonna do that quickly. As the case David spoke about highlights, public officials are really no strangers to critique, and not surprisingly, we at the ACLU are also familiar with those who detest us. And over the years, we've gotten a lot of laughs from some of the comments and letters we've received. So in the interest of lightening things up, I wanted to just share 2 real short ones with you before we move on to the next case. So also the acronyms on the screen are all ones that were created by our haters and shared in comments and letters, and we really get a kick out of them. So on our work generally, quote unquote, you can't get to the courts fast enough, can you, to uphold all that's rotten and depraved and inflict further misery on the innocent and good and moral. And then on our staff and our work generally, I've never yet met anyone from your group that comes close to being polite with people that don't agree with them, especially the feminazis. I mean, what the hell? Why have any rules at all? Having a society like Mad Max Beyond Thunderdome would probably be more to your liking. So yeah, that's it for that. Moving, it's a little just a little insight behind the scenes, if you will, taking me behind the scenes. So moving along with our program, I'd like to welcome cooperating attorney Lynette Labinger, who's going to talk about a recent reproductive freedom case. Hi, Lynette.
Hi, Nicole. How are you? So I'm here to talk about the Benson case, which is a challenge to the constitutionality of the Reproductive Privacy Act, or the RPA for short. In 2019, the General Assembly passed the RPA into law. Governor Raimondo signed it on the day that it got through the Assembly. And so the RPA is now the law in Rhode Island. However, the legal landscape of abortion rights, particularly on the federal level, has become even more precarious, if that's possible, since 2019. As many of you are likely aware, the US Supreme Court will hear argument next month on quote, whether all pre-viability prohibitions on elective abortions are unconstitutional, close quote. It is generally anticipated that the conservative court majority will jettison the principles underlying Roe. The RPA was passed because the legislators and the governors and the Reproductive Rights Coalition that had been advocating this for decades foresaw this possibility. The RPA serves 2 purposes. First, it codifies as the law in Rhode Island the protections of abortion rights established at the federal level through Supreme Court cases best known as Roe versus Wade and Planned Parenthood versus Casey. The second purpose was to repeal all of Rhode Island's anti-abortion laws that had previously been declared unconstitutional by the federal courts, primarily thanks to litigation by the ACLU, but were still in print in the law books. The reason was simple: to ensure that reproductive rights in Rhode Island will not be undercut if the standards of Roe and Casey are further cut back or even overruled by the US Supreme Court. Throughout the 70s, 80s, and 90s, the General Assembly passed laws designed to undermine Roe. And in 1986, a state constitutional convention led to both a successful attempt to add anti-abortion language to the Constitution, as well as an unsuccessful effort to create a constitutional prohibition, which would have absolutely prohibited abortion if Roe were ever overturned. Some version of the RPA has been introduced in the House or Senate pretty much every year since 1997, but always left to die before 2019. In 2019, we saw Roe was the law of the land, but constantly under attack, and Rhode Island still had no constitutional or statutory protection for reproductive rights. When the RPA was looking like it might pass in 2019, and it was clear that the governor would sign it if it did, a lawsuit was filed with the lead plaintiff, a man named Benson, as well as other plaintiffs, including 2 fetuses called Baby Roe and Baby Doe. First, the plaintiffs asked the Superior Court to issue an order preventing the legislature from sending the bill, if it was passed, to the governor for signature. The Superior Court refused to do that. After the RPA became law, the suit continued. In essence, the plaintiffs in Benson claim that the anti-abortion language added to the Rhode Island Constitution in 1986, that language, which is an anti-discrimination clause, which made clear that the prohibition against discrimination on gender did not create a right to abortion rights. They argue that it not only did that, but it also affirmatively prohibited the General Assembly from passing any statute creating abortion rights or protections. The Attorney General is defending the state, arguing that the plaintiffs in Benson have no injury and therefore no standing, and also that the anti-abortion language added in 1986 to the Constitution does not impose any restriction on the General Assembly passing laws preserving reproductive rights. The ACLU filed a friend of the court brief supporting the state. We pointed out the history of the 1986 Constitutional Convention, and that question 14, which was the proposed prohibition, which explicitly would have prohibited abortion, that it did not pass. And in fact, it was defeated by a margin of almost 2 to 1. The Superior Court agreed and dismissed the lawsuit. The plaintiffs have now appealed, arguing that they should get a chance to prove their case. And the case is now before the Rhode Island Supreme Court, where we have filed another friend of the court brief supporting the state again. While we are hopeful that the decision will be favorable to abortion rights in Rhode Island, the continued attempts to undermine abortion rights, both on a statewide and federal level, only underscore both the importance of proactive and protective legislation like the RPA and the importance of the continued involvement of the ACLU in the lawsuit.
Thank you so much, Lynette. Before we move on to our Q&A, Steve Brown, our executive director, is just going to say a few words about the importance of our work at the state and local level. Hi, Steve.
Hi, Nicole. Thank you. And thank everybody for attending this. Lynette's summary of the abortion case is a perfect segue to what I would like to briefly talk about. Right now we have a dysfunctional Congress. We have a backwards looking Supreme Court. And we have a large portion of the national populace that seems to be turning its back on civil rights and civil liberties. That's pretty depressing, but it's a mistake to solely look outward. I say this often, but I can't say it enough. The extent of our civil liberties and our civil rights boils down not to what's happening at the federal level, but instead what's happening right in our own front and backyard here in Rhode Island and in our communities. And the abortion issue is a perfect example. As Lynette explained, we've been fighting this issue for many, many years, for decades. We have had to challenge a number of state laws and have successfully done that. And the fact that the US Supreme Court said in 1973 that there was a right to an abortion didn't stop the legislature from passing laws trying to undermine Similarly, now that we have a Supreme Court that may be on the verge of eradicating or at least crippling Roe versus Wade, the work that was done here in Rhode Island to pass the Reproductive Privacy Act means that even without the federal courts helping, that right remains protected in Rhode Island. The fact that we're now on the Rhode Island Supreme Court to ensure that this victory is preserved is just another example of the critical importance of the work that needs to be done at the state level to protect our rights. And this analysis applies to really just about any other major civil liberties issue you can think of. We've covered a lot of topics this evening. There are many we haven't. For example, we didn't get to talk about racial profiling and the need for police reform. And despite these last 2 years of the Black Lives Movement and the terrible incidents we've all seen about police brutality, we know these are not issues that Congress is going to help out on. These are not issues the Supreme Court is going to help out on. It's going to have to, any change is going to have to happen at the state level. We've been working really hard here with many other organizations on state legislation to strengthen our anti-racial profiling laws, to require more police transparency. It's why we're in the courts addressing problems of racially biased traffic stops and police in our schools, as you heard Paige talk about. These are not battles that any congressperson or US Supreme Court justice or anybody in Washington is going to resolve for us. I don't want to suggest that what's going on nationally is irrelevant, but I do hope that tonight's program makes clear that here in Rhode Island, we can make a difference no matter what is happening elsewhere. So I ask you to get involved, sign up for our email alerts, attend our legislative advocacy training in the new year, follow our Twitter and Facebook feeds so you can keep informed on what we're doing, and take the time to let your state and local officials know you're watching them and demanding stronger civil rights protections from them. There's one other thing I hope you'll do, and that's make a special donation to our affiliate. I can assure you there is no lack of work for us to do. If you appreciate what you've heard tonight about our battles and successes, please help us continue to meet the challenges we're facing every single day by making a special donation. You can go to our website at riaclu.org or send in a donation. Would really be appreciated. It's your past support that has allowed us to do everything we've talked about today, and hopefully your continued support will help us as well. To wrap up, don't look at yesterday's election results or what's going on in Washington and give up hope. Instead, I hope you realize the impact that you can have right here and right now, because at the end of the day, right here is where it ultimately counts. So again, thanks for taking the time to attend, and I'll throw it back to Nicole so we can wrap up and maybe take a few of your questions.